Good morning to everyone. Today's session is by Mr. Bandish Soparkar on virtual currency. Mr. Bandish Soparkar is one of the brightest young lawyers we have at the bar. He has done his chartered accountancy and LLB. His practices at Income Tax Tribunal and High Court. Today's session is on virtual currency. This session will help us understand what is virtual currency or cryptocurrency, how it came into existence, why it was prohibited by many countries, and what the Supreme Court held in the recent judgment. Thank you, Vandish, very much for conducting the session.
Thank you, Ashit Bhai. This is a very good opportunity for me to study deeper into certain subjects and then share my thoughts with all of you. I will be taking you to the slides, but before I do that, I want to explain that I will be dividing this talk into broad three logical fragments. In the first, I will be telling you about what is money. The second, we will go to understand what is virtual money, what is virtual currency. And in the third segment, we will discuss about how in the Indian scenario, the story progressed and how the government tried to curb it and what Supreme Court did. So before I begin with the first, let us begin with the story. This is a story about a camel herder in Rajasthan. Now, the camel herder used to go from place to place along with his camels. He would let camels roam free during the day, and at night he would tie them up with a rope with a tree so that the camels don't run away. Now, one day in the evening, while he was tying the camels with his rope with a tree, the rope broke off, and this camel herder was very much worried that his camels would run away. And so he was worried that how do I ensure my camels don't run away? I don't have a rope right now. It is broken. What do I do? A guy was passing by and he saw his dilemma, and he offered a solution. He said, "Don't worry. You don't have a rope, but enact as if you have a rope and make the same performance with a rope and a camel, believing that you have a rope." And he did that. He sort of went close to his camels, close to the tree, enacted as if he had a rope, and the camel sat down. And for the whole night, camels did not move, and he was able to ensure that camels don't run away in the night. In the morning, he went to the market and bought the new rope. The moral of the story is that the camels imagined that there was a rope. The camels were not able to distinguish between the real rope and the rope that was not there. The camels imagined the rope, and therefore the camels stayed there. What is the rationale of this story with our subject? The rationale is we are prisoners, same as camel in certain terms. We are prisoners of our own imagination. And the imagination for our topic is money. Now let me get the presentation to start and explain what I'm talking about. I'll share my screen. Okay, I hope everyone can see my screen. Wait, let me. Can everyone see my screen? Okay, so we are the prisoners of our own imagination because we imagine in something called money, which is this piece of paper. The question is, did we always have money? The answer is no. We did not always have money. The money is a pretty recent phenomena in the civilization of mankind. The trade and commerce is not. We always traded goods with people. But before the invention of money, we use the barter system. The barter system, I make a piece of cloth, you have wheat, I give you my piece of cloth, you give me wheat. But there were two major problems with the barter system. First problem was the coincidence of wants. I may have a piece of cloth to give, but you don't want a piece of cloth. I want a grain, but because you don't want a piece of cloth, you will not give me your grain. So we need to find a third person Who would want my piece of cloth? Who would give me something which you want? So we had to look for the coincidence of want. And therefore, there was a need of the intermediary to eliminate this coincidence of want and make the trade and commerce smooth and free. That is the reason why money came to be. But money as an intermediary was not piece of paper for always. Earlier, it was the gold, silver, Cody has also been used. The earlier intermediaries, where it was a gold, the intrinsic value of the gold was the nominal value of the gold. Meaning thereby, if a piece of gold, it was worth the gold in it. It did not, if there was 10 grams of gold in it, then whatever the price of the 10 grams of gold is, that was much the coin was worth. But today, if this piece of paper says 100 rupees, this is not the cost of this piece of paper. This piece of paper probably costs, the cost of this making of this piece of paper is less than maybe a rupee. But yet, this allows me the purchasing power of 100 rupees. So, how is this piece of paper any different than, let us say, this piece of paper, which is a monopoly card, or this piece of paper? Coming back to the point, we are all prisoners of imagination. We all have imagined and we all have agreed in believing in this piece of paper. What it does is, any money, regardless of paper, any money does three things. One, it is a storage of value. It stores a value. This piece of paper stores a value of 100 rupees. This piece of paper stores a value of 500 rupees. Second thing is, it is a medium of exchange. One can give this piece of paper and get goods worth 100 rupees or 500 rupees. Third, it is a unit of account. If you go to the market, you want to buy wheat, you don't say give me 700 pieces of wheat. You say give me half a kilo of wheat. The half a kilo is a medium of account. As far as money is concerned, money itself is also a medium of account. Because we don't say I have 5 pieces of paper which looks like green. We say each piece of green paper is worth 500 rupees. I have 2500 rupees. So money is also a unit of account. So every money will be having three characteristics: storage of value, medium of exchange, and unit of account. One more thing that this piece of paper has, as opposed to this piece of paper that we use in Monopoly, because this is also storage of value, which is this $20 as opposed to this $10 as opposed to $20. This is also a medium of exchange because we buy and sell properties, make house and hotel in Monopoly. This is also a unit of account. What differentiates this piece of paper from this piece of paper is that this piece of paper, someone has promised us. The promise is by the governor, RBI, which says, I promise to pay the bearer the sum of 500 rupees. There's a centralized issuing authority, which is in this case RBI. Just as a fun fact, RBI issues all the notes except 1 rupee note. In a 1 rupee note, you will not find this word of promise. RBI Act itself says, for some reason, central government has power to issue 1 rupee notes. So all notes except 1 rupee notes, it is backed by a promise of the RBI governor. It is backed by the RBI, which is a central issuing authority as far as India is concerned. And that has issued this piece of paper that all of us have agreed to until demonetization happens. Then the same 500 rupee note of the earlier kind, no one agrees to it anymore. Okay, so RBI issues this note. But is there a limit to how many notes RBI can issue? Earlier, there used to be certain limits which were directly linked to the gold reserves of that country, which limited that if you have this much gold, only then you can issue this much money. You cannot issue more money than the gold. But those standards are given up by all countries now. Therefore, theoretically, the RBI is free to print any number of money that they want to. And they a lot of times do print a lot of money for various reasons. And that leads to certain problems. One of the reasons why RBI does this, uh, let me see, let me explain. Okay, I'll explain why would be the need for RBI to do this. Let us say we are 20 people, we all have 10 rupees, and we put that 200 rupees in the bank. Now the bank has 200 rupees as deposits of 10 rupees each from all 20 of us. Two of us need the loan from bank, and two of us need the loan of 100 rupees each. So the whole 200 rupees of the bank went as a loan to two people. So all our deposits have gone to two people. Let's say for some reason those two people are not able to repay back. They have gone bankrupt. There is an NPA. So the bank is not able to recover any of that money back from those two people. So 18 of us have lost all money. If any of us go back to bank and say, give me back my 10 rupees, the bank says, I'm sorry, I gave those 200 rupees to these two people and they have not repaid me back. So I have no money left. Bank prints money then. Let us say that earlier all of us put 10 rupees, so the capital was 200 rupees. Let us say now the bank has printed again 180 rupees back so as to repay 18 of us back. Therefore, the total circulation of money, which was originally 200, has now gone to 380 because 200, which the two people took and never gave it back. It's not as if the money is uh, vanished in the thin air. The money is somewhere in the system. He must have paid in getting house or factory or whatever, whatever. But the bank is now again reprinted 180 rupees. So now there are 380 rupees in circulation. What that does is it decreases the value of money. It decreases the value almost by half. When there were 200 rupees in the circulation, what you could buy in 10 rupees, now with 380 rupees in circulation, you will need 20 rupees to buy the same thing because the money, the amount of money in circulation has increased almost by double. I bet 380 it could be 400, but that has doubled. So that amounts to debasement of currency because they have issued more notes. That leads to inflation. So someone did the statistical analysis that in 1970, a coffee that was costing $0.25 is now costing $1.59. That's the inflation in America, which is far lesser than in India. In India, the inflation is far greater than America. The motive of this history is because of this characteristic of the centralized issuing authorities' power to issue money as and when they want is the reason why Bitcoin or any virtual currency has come to be. We all know that in 2008 there was the subprime crisis in United States. A lot of people could not repay money back to their lenders, and consequently lenders could not back to their own banks, and therefore banks had to undergo a lot of NPAs, and therefore the government printed a lot more money to recapitalize the banks. It led to debasement of money, and a lot of people were unhappy with this. So some of the mathematicians, intellectuals, economists struggle with an idea that how do you overcome this abuse of centralized power, that they are able to issue as many notes as they want. As a result, they invented something called virtual currency. So virtual currency. Okay, am I audible to everyone? Am I audible? Archit, am I audible?
Bandish, there was an echo. There was some.
Sorry, now is it okay?
No,
It is not okay.
there is some disturbance, Bandish. We could not.
Okay. Is it a disturbance of some? Can you turn off this fan, please? Let's see if the fan is having a disturbance of some kind. Is it any better?
Yes, Mandish, we can start. We can.
Okay,
If
let's
there is
start.
any issue, we will let you know.
Okay, understand. So that gave rise to the virtual currency. The very objective of virtual currency, the maker of the virtual currency was quite clear about why he's doing this. He says the root problem with the conventional currency is all the trust that is required to make it work. The central bank must be trusted not to debase the currency, but the history of fiat currencies is full of breaches of that trust. Satoshi Nakamoto was the inventor of virtual currency. He is an anonymous guy. No one knows who this Satoshi Nakamoto is, where he lives, what he does. He has existed on internet, but no one knows who the real person is. People speculate that there may not be a single real person. It might be group of people going by the name of Satoshi Nakamoto, but we don't know. We don't know. Let's see. Uh, this another guy was the student in Helsinki University. He joined Satoshi Nakamoto in his making of Bitcoin. He said, "Be safe from the unfair monetary policies of the monopolistic central banks and the other risks of centralized power over a money supply. The limited inflation of Bitcoin system's money supply is distributed evenly by CPU power throughout the network, not monopolized to a banking elite." So the birth of virtual currency is very clearly a rebellious revolution against the conventional system of currency and finance. But it has worked so far in most of the countries. What is a virtual currency? It is nothing but else but a digital representation of the value that can be traded digitally, not having a legal tender status, because there is no centralized issuing authority. No country is backing it up. It is backed up on its own. It is a math-based, decentralized, convertible virtual currency protected by cryptography by relying on public and private keys to transfer value from one person to another and signed cryptographically each time it is transferred. I will explain how this happens in the later slides. But for the time being, imagine it is uh, like a Paytm money, except it is not a rupees. It can be Bitcoin, it can be zero coin, it can be different other hashes, uh, but it is not backed up by any centralized bank. The characteristics, it is a digital in nature. It is private because it is not centralized. It is global. It is run on autonomous, decentralized algorithm. The rise of virtual, it is pretty recent concept. It was invented in 2008. It is pretty recent. But the rise has happened due to development of the blockchain technology. The blockchain technology is the technology which ensures this works, which ensures it is secure, which ensures it is functional. uh, the concerns about conventional money and the banking post 2008 crisis, the privacy concerns, and the political view about the role of the government. Different countries are still in a dilemma as to how to view this particular thing. Is it a property? Is it a commodity? Is it a currency? But the question is still not very clear, and globally there is no consensus about it. Because global there is no consensus, different countries also treat it differently. Some countries completely allow it, some countries are not very clear whether they allow that or they don't allow, and some countries completely do not allow. Talking about the pricing, how it works, just to give you an idea how volatile this currency is. In July 2010, the price of one Bitcoin was $0.008, which in February 2011 came to be $1. So $1, one Bitcoin in February 2011. Coming to 15, on 20th November 15, one Bitcoin was 21,000 rupees. On 15th of December 2017, one Bitcoin was 12.60 lakh rupees. And as on yesterday or 2 days ago, on 1st of May 2020, one Bitcoin is 6.78 lakh rupees. So practically when the transaction happens at 0.23, 0.02 Bitcoins. The Bitcoins are possible to fragment. It's not as if one whole Bitcoin has to transfer the hands. Now, how does it work? As I said, it is created by the unknown Mr. Satoshi Nakamoto. It is a peer-to-peer. There is no centralized authority. It goes from a person to person, hand to hand. It is a fast. It is anonymous. There is no fee because there is no intermediary. You don't require any bank account. It is decentralized. It has a global reach because of internet. A person sitting in India can transfer the money to person sitting in America or Uganda or Australia immediately. The downsides are there is no insurance. It is not widely accepted. Whosoever will accept it. Whosoever do not accept will not accept it. The prices are highly volatile, as I said, and the payments are irreversible unless the person is generous and he gives you back. But it is not as if it's a reverse. It is not an elimination of earlier entry. Each entry is one more entry on the top of it. It is not physical. It is not stored in a physical wallet. It goes in the computer programs or mobile phone. Now, how do you acquire a Bitcoin? You can either mine a Bitcoin, which is you can do complex computer functions. You can make your computing power available to the system and you can be rewarded in Bitcoin, or you can purchase Bitcoin from the exchange. It is very important to understand the role of the exchange because that is where the whole heart of the controversy in the Supreme Court judgment is. Exchange is a person who has both, who has currency and a Bitcoin, and he is ready to exchange one for another. If you give him Bitcoin, he will give you currency. If you give him currency, he gives you Bitcoin. Exchange, therefore, you can either buy Bitcoins from exchange at a prevailing rate. You give 6.78 lakh rupees to the exchange, and the exchange will give you one Bitcoin that you can keep with yourself. Or you can mine your Bitcoin. Once you have a Bitcoin, you can transfer the Bitcoin for any reason. You can just gift a Bitcoin or you can receive goods or services against this Bitcoin. As the judgment also says that some restaurants in Bombay and Bangalore accepted Bitcoin as a valid currency. All over world, a lot of other places in America, Australia accept Bitcoin as the valid currency. So you can get goods and services for Bitcoin. How does Bitcoin work? What is blockchain? So let me explain, and then in the middle I will explain how this happened. So if A wants to send money to B, then he will execute the transaction through his application on his phone, which says that he has a Bitcoin. Then that transaction is constituted as a block. The unique feature of the blockchain, which backs the virtual currency, is that it is a distributed ledger. Unlike a centralized system where one person is recording all the transaction. For example, we know in our, if I have a bank account in HDFC Bank, HDFC Bank is the one which is recording all the transaction of all of its customers. But in this case, all the transactions that happen in Bitcoin are recorded by everyone who is maintaining these records. And there are multiple parties who are maintaining these records. So let us say there are 1,000 computers that are maintaining records of the transactions that are happening in Bitcoin. So let us say if I want to give one Bitcoin to Archit, then this transfer of Bandish to Archit, one Bitcoin will be recorded in all 1,000 computers. And unless all 1,000 computers approve of this transaction of Bandish to Archit, one Bitcoin will not be executed. And what this all 1,000 computers will do, all 1,000 computers individually within themselves will check how did Bandish have to happen to own this Bitcoin. They will trace back my transaction to check that Bandish's existence, ownership of this one Bitcoin, is it legitimate? They have recorded every transaction that ever happened in Bitcoin. So they are able to trace back every transaction that had ever happened. So they will trace back, okay, Bandish got this Bitcoin from Mr. X. Did Mr. X have a valid Bitcoin? Mr. X got from Mr. Y. So they will trace it back to the mining field. It is a lot of computation, but the computers are able to do with the digital technology. So once they are able to trace it back that from the mining Mr. C had which gave it to Mr. Y, which gave it to Mr. X, which gave it to Bandish. Therefore, Bandish is legitimate owner of this Bitcoin, and therefore now he is given to Archit, and therefore Archit is now legitimate owner of this Bitcoin. This fact that Archit is now legitimate owner of this one Bitcoin will also be recorded in all 1,000 computers. So that when Archit will further transfer it to someone, all 1,000 computers will approve of this transaction, that Archit is a legitimate owner of this one Bitcoin. So this is the distributed ledger technology, which is mathematically absolutely foolproof. There is no way to hack this. Absolutely no way to hack this. Unless you hack all the computers in the system, which is practically impossible. That you hack all the computers in the system. It is possible to hack one computer, two computer, five computers. But because this all the computers in the network are dispersed throughout the world, it is practically impossible to hack all this computer. Unless you hack all this computer, all of them are not going to approve of this transaction. So this blockchain technology is supposed to be the most secured record keeping technology. And virtual currencies are backed up on this technology. So, okay, now let me come to the part of what has happened in the timeline of Bitcoin qua India. It was in 2013. 2008 was the invention of Bitcoin. Between 2008 and 2013, nothing happened in India. People were just waiting and watching the regulatory authorities. But in 2013, RBI first issued the first press release cautioning people against the use of virtual currency because of the price volatility. They said this is not recognized by anyone. The prices are highly volatile. Be cautious about using this. You may incur into huge losses. The Financial Action Task Force, which is the intergovernmental body to curb the money laundering and terrorist financing. This intergovernmental body, which India is also part of, issued a report on the internet-based payment systems. This was on RISE, but they did not address the virtual currency specifically on this. Later in 2014, they further came up with a report to define the virtual currency and the potential of it being used as a tool for money laundering and terrorism financing and how to address it. The Bank of International Settlements, which is the organization of 68 central banks of countries around the world, and RBI is also one of the member bank of this organization, also came out with a report on digital currencies. And for the first time, the financial stability report of RBI also noted there was a need to keep pace with the developments, and therefore they were quite positive with the blockchain technology. And most people throughout the world have been that this blockchain technology is quite good to look at to maintain the records of the securities market, the insurance market, because it is absolutely secure, foolproof technology. But people were lukewarm towards the Bitcoin and other virtual currencies. In 2016, the RBI report further said that financial regulators really need to gear up to adopt the technology because technology is changing quite fast and countries around the world are using blockchain technology to maintain the record, to enter into transactions. But in India, the finance regulators are not doing any of that. So RBI recognized there is a need to adapt. In 2017, the Institute of Development for Research in Banking Technology submitted a white paper of application of blockchain technology to banking and financial sector. Again, they were positive towards blockchain, but they were still not easy with the Bitcoin and other virtual currencies. RBI later in 2017 issued two caution press releases against the use of VC. Later on in 2018, the G20 meet happened of the finance ministers and central bankers. They recognized the advantage and risk of the cryptocurrencies and assets. They were also in a dilemma as to how to recognize this, how to deal with this, what sort of regulations we should make. Should we uh, positively work towards its development or should we curb this? All of them were in different minds. But suddenly on 5th of April, and this is the core issue that we will be dealing with, RBI prohibited the regulated entities to deal with anyone who deals in VC. And they said if any bank is dealing with a person who is dealing in virtual currency, discontinue your relationship in 3 months. This is the heart of the uh, action that we will be dealing with. Later on in 2018, Interministerial Committee report further came out with their bill, which is Indian bill of crypto token and crypto asset bill of 2008. The Supreme Court decision also deals with this, so I will explain what this bill does. But somehow this bill is not available online. We cannot see it. Later in 2019, they came up with another bill. This bill has not yet passed in the parliament, so this bill has not made into an act. We will see what happens to it. In 2019, the Financial Action Task Force came out with another report on how to approach this, what is a risk factor, and what you should do. Okay, so this was the RBI's notification of 6th April. What it does, the para number 2 is very important. Uh, so I'll read the full notification. RBI has repeatedly, through its public notices on December 24, 2013, February 1st, 2017, and December 5th, 2017, cautioned users, holders, and traders of virtual currencies, including bitcoins, regarding various risks associated in dealing with such virtual currencies. In view of the associated risks, it has been decided that with immediate effect, entities regulated by the Reserve Bank shall not deal in virtual currencies or provide services for facilitating any person or entity dealing with virtual currencies. Such services include maintaining accounts, registering, trading, settling, clearing, giving loans against virtual tokens, accepting them as collateral, opening accounts of exchanges, dealing with them, and transfer receipt of money in accounts relating to purchase and sale of VCs. Regulated entities which already provide such services shall exit the relationship within 3 months from the date of the circular. Okay. It does two things. It says that no RBI regulated entity, which means all the banks and non-banking financial companies and financial institutions, they will not deal with any person who is dealing in virtual currency. So RBI has not prohibited the individuals from dealing in virtual currency. If I hold a virtual currency and if I trade in virtual currency, the RBI has not directly affected me. They have not said that Bandish, this virtual currency that you are holding is henceforth illegal, so dispose it off. And if you do not dispose it off, if it is found that you are holding this, they will find you prohibiting the law, violating the law. No, they don't do that. They tell my HDFC Bank that HDFC Bank, Bandish is our customer. Bandish is holding virtual currency. He is dealing in virtual currency. Remove his account. So RBI has directed all the banks to sever that relationship with any person who is dealing in virtual currency. This is very, very important to understand what is the action of RBI to analyze how to counter this action. So, hold on, let me exit my WhatsApp, otherwise it will keep on buzzing. Okay. All right. So RBI has directed their own regulated entities. So this notification is addressed to banks. This notification is addressed to NBFCs. This notification is addressed to all those banking companies who deal eventually with the companies or individuals. This notification is not issued to the individuals in the first place. But as a consequence to this notification, the banks will have to close down all the accounts of the individuals or the account holders who deal in virtual currencies. And that is how indirectly it affects me. Now, that is why the petitions are filed before the Supreme Court against this notification. And the arguments of the petitioner in this case are these. The arguments they make is, the first argument is a very interesting argument. They say that virtual currencies are not legal tenders. They do not fall in the credit system. No one takes loan in virtual currency from banks. No one makes deposit in virtual currency to banks. It is not a legal tender. Therefore, it is beyond the jurisdiction of RBI. RBI is a body which is completely has all the power to regulate the money, regulate the finance systems, regulate the loan, the interest. But the RBI does not have power to deal with something that is not the virtual currencies. And Bitcoins are not virtual currencies. And therefore, RBI has no jurisdiction to deal with this. The second argument that the petitioners made is some noise from someone. Okay. The second argument that was made was that assuming RBI has power, but there are principles how they can use this power. There has to be an application of mind. This issuance of notification is a colorable exercise of power. This is not acceptable. There is MS Gill reasoning, which I will come to later on, how Supreme Court explains. There is a rule of proportionality. The third argument was that all other Indian stakeholders have recognized the positives of and beneficial aspects of virtual currency, and the further bill of 28 and 29 that they are pending. They say that other nations have also not found anything wrong with them. Many nations have approved the virtual currencies. They are dealing with virtual currencies. Why India is banning them? They further argue that RBI should have recognized the petitioners have taken proper precautions, that the petitioners have, as much as they are exchanges, they have taken precautions where they have asked for KYC of all their customers. They are keeping all the records. They are maintaining all the information and making it available to the government. So therefore, there is no need to ban this. They further said not every virtual currency is anonymous. There are anonymous and there are pseudonymous. So don't treat everything same. They further say that blockchain is acceptable to everyone, then why not virtual currency? That RBI is a creature of the law, RBI Act. RBI is not the law making authority. Therefore, the the RBI's action, the court must look into it and not consider that this is something an expert body is saying, the legislature is saying, and therefore the court should not show restraint in dealing with this executive order. The last argument is that it violates the 19(1)(g), the freedom of trade and commerce. The petitioners were of two kind. One kind of petitioners were the holders of the virtual currency, they were the traders of the virtual currency, they were individuals. The other kind of petitioners were the exchanges. They were the people who were dealing with virtual currencies, as they were exchanging virtual currency against money and money against virtual currency. So if anyone in India wanted to buy virtual currency, they would have to go to these exchanges. There were three exchanges. They were part of this petitioner, with a group of petitioners. These exchanges, one would have to go to these exchanges and convert their rupees into the Bitcoin. Of course, this would take place by way of the recognized banking channels. That was not a doubt about it. These exchanges said that if we are cut off from the banking channel, if we are not allowed to open bank account and borrow money or deposit money, we cannot run our exchanges, because then there is no exchange. We will only have Bitcoin, but we will not have money to give it back. So they were the directly affected people by this RBI notification. What RBI said? RBI said that virtual currencies are not currencies. Virtual currency exchanges do not have the mechanism for consumer grievances. Virtual currencies are capable of being used for illegal activities due to anonymity. Increased use of virtual currencies can destabilize the entire currency and trade system. Therefore, RBI has to come in play, and RBI has all the power to do this. But the decision of RBI is legislative in character and in the realm of economic policy decision taken by the expert body, and the court should not interfere. They further say the decision is within the powers of RBI Act, the Banking Regulation Act, and the Payment and Settlement Systems Act. They say that there is no unfettered fundamental right to do business with the entities regulated by RBI. The one cannot say they have a fundamental right to open a bank account. One cannot have a fundamental right to do transactions through banking systems. That RBI's decision is not excessive, confiscatory, or disproportionate. They have anyway given a 3 month window. It is not as if the accounts are frozen, the money is not given back. A 3 month window is given to sever the relationship. This is nothing wrong in it. This is there's a complete application of mind. The RBI has been mulling over this issue since 2013, and only in 2018 they have taken this decision. There have been multiple research reports. So therefore, this decision is taken in the public interest to protect the consumers, the payment systems against the volatility of the virtual currencies. And they said there is no complete ban, either on virtual currency or blockchain. This is if the virtual currency is a peer-to-peer system, it has a potential to become a parallel payment system. The KYC norms are not satisfactory, and therefore RBI has all the power to deal with this. Supreme Court dealt with these issues in largely four brackets. That is examined one by one. The first bracket: does RBI have the jurisdiction to issue this notification? The first argument that was that virtual currencies are not money at all. These are not currencies. These are not legal tenders. These are not the part of finance credit system by which the loans are given or taken. Therefore, RBI has no power to deal with this. The Supreme Court says no. RBI does have jurisdiction. Why Supreme Court says so? The Supreme Court says let us examine what is a virtual currency. The Supreme Court is saying that it is not possible to accept the contention of the petitioners that virtual currencies are not money and they are just goods and commodities. They examined various foreign decisions. The facts are quite interesting in those decisions. Some of the American decisions that the Supreme Court deals with relate to people who defrauded, who ran the Ponzi scheme through the Bitcoin uh, medium. The argument of the accused in these cases was that, okay, even if I did this scheme, I have not defrauded people of money. So therefore, in so far as the law recognizes defrauding people of money, I have not defrauded people of money because Bitcoin is not money. And the district court in US in that case said no, this is money. You have defrauded people of money, and therefore we are going to punish you. Another case in the US District Court was regarding the Silk Road. Silk Road was a very famous website that facilitated the buying and selling. It was a marketplace, but a marketplace for all the illicit goods, drugs, uh, and that website was running through something called Tor, which is a dark net where the IP of the computers are not traceable. The founder of that website was found guilty for various charges, including murder charges. But his argument was that I have not dealt in currencies, I have not dealt in legal tenders, and therefore, so long as these exchanges happened, this is a marketplace, and therefore, I am not the offender of any crime as per the law that stands, which requires currencies to be part of the offense. But the courts in US said no. Bitcoins are the currency in a way they are used in the real sense, where someone has accepted that as a payment. The Supreme Court also looks into the decision of the Future Trading Commission of the United States, where the offense was recorded against uh, an exchange, commodity exchange player who used Bitcoin in the future transaction. This Future Trading Commission said that Bitcoin is a commodity and therefore you have to abide by the rules of the commodity exchange. And that the matter went to court, and that person accepted that Bitcoin is a commodity. Later on, in the UK, the High Court came across a very interesting facts. For an insurance company, there was a hacking attack, which is called ransomware. Ransomware, what happens in ransomware is the hackers don't take away your data, they encrypt your own data so that you cannot decrypt your own data and you cannot use your own data. So, a hacker hacked into the system of an insurance company. It encrypted the complete data of this insurance company so that insurance company could not use its own data. And the hacker said that if you want to use your own data, if you want your own data back, give us $1 million, then we will give you back your own data. The insurance company tried a lot, but they could not decrypt their own data, and this hacking was very very real. So they did pay bitcoins worth $1 million to these hackers, and the hackers provided them the decryption tools, and this insurance company was able to retrieve its data back. But this insurance company, what they did was they hired an investigator to trace this bitcoins on the exchange. And they were able to trace that this 109 bitcoins that were equivalent to $1 million, this 109 bitcoins went to a particular entity of the British Virgin Islands. They went to the UK court and say that freeze those assets, that these are the people are holding the 109 bitcoins that I paid, that they are the people who encrypted my data and hacked into my system. So UK court was examining the law regarding freezing of property. That is this Bitcoin property that they can freeze this, and they ruled that yes, this is a property that they can freeze. The Supreme Court does not tell whether this was eventually they were capable of freezing or not. I do not think that they will be capable of freezing this. But nonetheless, the UK High Court came to a conclusion that bitcoins were properties that could be frozen. So our Supreme Court, while it came to conclusion that this is money, they said that now our job is easy. Once we are able to identify that virtual currencies are money so long as it is accepted as a payment, RBI has the jurisdiction to deal with something which can be accepted as a payment. This is the statutory obligation of RBI as a central bank is to operate the currency and the credit system, to regulate the financial system, to ensure the payment systems of the current country to be on track, and that would compel them naturally to address all issues that are perceived as potential risks to monetary, currency, payment, credit, and financial system of the country. If an intangible property can act under certain circumstances as money, then RBI can definitely take note of it and deal with it. Hence, it is not possible to accept the contention of the petitioners that they are carrying on an activity over which RBI has no power statutorily. Okay. So second argument was that even if they have a power, they have a power to regulate but not prohibit. So Supreme Court said no. Regulation includes prohibition. They further said that they further argued that even if this is prohibited, they could not prohibit through executive action. They could prohibit through legislature. The Supreme Court said no. The Korea Distilleries case is very clear that they say that while dealing with prohibition of an alcohol, it was held that what articles and goods should be allowed to be produced, possessed, sold, and consumed to be left to the judgment of legislative and executive wisdom. Therefore, they said that RBI has a power to do this as well. And further, Supreme Court said that RBI has not prohibited in the first place. There is a question of regulation, not prohibition. The RBI has only debarred their own regulated banks to deal with anyone who holds a virtual currency. So where is the question of virtual currencies being prohibited in the first place? So therefore, your whole argument of regulate prohibit is out of place. Then there were series of arguments that they said that there is no satisfaction recorded, there is no application of mind. The Supreme Court said no. The RBI has been mulling over this issue since 2013. They have been looking into various reports, international reports. RBI has applied its complete mind. Then they say that the petitioners say that there is a malice in law, culpable device. They say so because they say that in an RTI made to RBI, and as well as there was a question asked in the parliament, it was said that virtual currencies are not prohibited in India. So therefore, the argument of the petitioner was, when the virtual currencies are not prohibited in India, then by this notification, you have indirectly done something which you could not do directly, or which you did not plan to do directly, or what you said that you do not want to do directly. And the Supreme Court said, no, there is a complete mismatch between your argument. The virtual currencies are anyway not prohibited. The stand of RBI and the member of parliament are not contradictory. They said the virtual currencies are not prohibited, they are still not prohibited. So this order of this notification of RBI is not as if it is opposite to what they said earlier. It is very much in tandem with that. Then the argument of the petitioner was that it violates the MS Gill test. The MS Gill is a decision of the Supreme Court of 1978, 1 SCC 405. In this decision, the Supreme Court said that there has to be natural justice, that the audi alteram partem, the right to be heard, should be given, the notice should be given to the offended party, and they should be heard, all of that. The Supreme Court said no. So the argument of the petitioner was that they came out with this notification without giving any notice, without asking for any explanation. The Supreme Court said nothing is required. MS Gill test doesn't apply to the larger public interest is involved. They relied upon a few of the later decisions which laid down this principle. Then the petitioner's argument was that many other stakeholders like Enforcement Directorate, SEBI, and CBDT, they all have dealt with this dilemma and they have not come out with any prohibitory measures. The Supreme Court said that all of them have different functions. They may come out with the prohibitory measures if they feel like in their own field. RBI right now has failed to come out with something which is in their field. You cannot say that, oh, but Enforcement Directorate has not done that. Bad argument. One more argument of the petitioner was that the other countries have not dealt such harshly. Supreme Court said that what other countries do, we are not concerned with that. One more argument of the petitioners was that we have taken precautionary steps. All the transactions are done through banking channels. We have KYCs in place. We know identity of everyone. That there are different virtual currencies. What we are dealing with are not anonymous. The Supreme Court said we are not experts to say on this. RBI is an expert, and RBI will deal with this. The last thing they said that the RBI's decision do not qualify judicial deference. So judicial deference is a principle where the Supreme Court will not enter into issues which relate to economic policy, taxation, and all of that. And the argument over here was that in as much as a legislative action or law may have a higher pedestal to stand, a notification by RBI cannot have the same stand, and therefore the Supreme Court must intervene and not give this notification as much high a position as any other law of dealing in economic realm. The Supreme Court said no. RBI is not just like any other statutory authority. It is a very unique authority. It is not like a stream which cannot be greater than its source. They said it is the only authority, central authority in India. It has the exclusive realm to deal with this issue, and therefore we will respect RBI's position on this. But on the fourth ground, the Supreme Court strikes down this notification. The Supreme Court strikes down this notification saying that it is disproportionate. Okay, now this is important why Supreme Court does this. Supreme Court does this because Supreme Court recognizes that there are two kinds of people that are affected by this notification. There are two kinds of people who deal in virtual currencies. First are the kind of people who are individuals who hold the virtual currencies and who trade completely in virtual currencies. They do not convert them into money at all. They hold it for because they believe that the prices are going to rise in future. They hold it for hobby. The Supreme Court say that these people are not affected by this notification at all, in as much as there is no prohibition against holding of virtual currencies. The second kind of people, who are the exchanges who hold bitcoins and who convert the bitcoins into money, they are the people who are affected completely by this notification. So first, Supreme Court made a distinguishment between these two classes. And the Supreme Court said that the real vice with the virtual currency, that the experts, those who are against it, are against the virtual currencies because the potential of virtual currencies of dealing in illegal activities. But therefore, this notification does not address that concern at all, because this notification does not prohibit virtual currencies. Therefore, this notification, although the regulators wanted to curb dealing in virtual currency, they have done this indirectly by prohibiting the second class of people to curb the first class of people. Recognizing this motive behind the prohibition or the regulation, the Supreme Court then examines the test of proportionality. Now, the test of proportionality is a recent concept in the, as far as India is concerned. Only in 2016, the modern dental college decision of Supreme Court first is the first one to deal with the proportionality concept. But the concept of proportionality works in tandem with the concept of reasonableness. We are all aware that Article 19(1)(g) gives a freedom of trade and commerce, but it is subject to reasonable restrictions. Now, the Supreme Court has begun to read the reasonability of these restrictions with the proportionality. That if the restrictions are proportionate, then they are reasonable. And then if they are reasonable, the 19(1)(g) is not violated. So therefore, if it is not proportionate, they are not reasonable, and then 19(1)(g) is violated. The Supreme Court in this decision traces the whole origin of the principle of proportionality from the 1999 Privy Council decision, and later on the Supreme Court of England decision. And they say that there are four tests. First test is that the measure must be designated for a proper purpose. The purpose cannot be wrong purpose. Once the purpose is correct, the measure has to be rationally connected to the fulfillment of that purpose. The third condition is that there has to be no alternative less invasive than this measure. If there are any other less invasive measure available, then the authority must apply that measure. The authority cannot say that because I can apply greater measure, I will apply greater measure. It has to be narrowly tailored, and the least intrusive measure must be applied. And the fourth is that there is a proper relation between the importance of achieving the aim and the importance of limiting the right. Therefore, in this case, the Supreme Court examined two aspects. First was a bank mallet case. It was a very interesting case of the Supreme Court of the England. In that case, under similar circumstances, a notification was passed to debar an Iranian bank to deal in the financial market of UK, because the regulators believe that this Iranian bank is connected with the financing of the nuclear program back in Iran. And therefore, they did not want this bank to work in UK. So Bank Mallet, the Iranian bank, challenged this ordinance, and it succeeded. It succeeded on both counts, the substantive ground and the procedural ground. By 6-3 majority on procedural ground, Supreme Court gave the decision in favor of the Bank Mallet, and 5-4 majority, they gave the decision in the favor of the bank. And they said that they all agreed that the realm of economic and taxation matters must be given exclusive jurisdiction to the legislative bodies, and there is always a need of the national security, all of that. But they said that they are not absolute bars, that the moment you say national security, the court is not going to intervene at all. The court will look into how you have addressed the problem, what is the problem, how you have measured the problem. So the Supreme Court said that in this case, this is a complete case of arbitrary measure. The Supreme Court says that, the Supreme Court of UK says that you have arbitrarily picked this bank. There are other Iranian banks as well, and you have not come out with the reasoning why this bank is associated with the Iranian nuclear program. They also say that this is the risk that you are talking about, that this bank can help finance the nuclear program, is an inherent banking risk. that any company who's into banking is going to make money, and there is going to be taxation of the country. So this is inherent banking risk. You cannot pick and choose one bank and debar that one bank. So this was the bank ballot case. In EU Parliament report as well, the EU Parliament recognized the potential of the, hold on. So EU Parliament, hello, there is some noise at the back. Thank you. So EU Parliament also recognized that there are two kinds of virtual currencies. One is there is there is some okay. So the EU Parliament said that there are two kinds of virtual currencies. One is anonymous and one is not completely anonymous. As long as those currencies which are completely anonymous, they should be curtailed. But those currencies which are not completely anonymous, we should not ban them. They said that if the potential is against the misuse, potential is against the committing of crime, then we must focus on those crimes directly, then indirectly going through the route of banning the non-anonymous virtual currencies. So this was a EU parliamentary report. Both these reports, the Supreme Court examined in detail, and the Supreme Court struck down the notification because of three reasons. One, they said that RBI has not so far found the activities of virtual currency exchanges to have actually adversely impacted the entities regulated by RBI. They say that RBI has not come up with any facts that the entire credit system of the banks is falling down because of these exchanges. There is no data. If you have this argument, then justify with data. The second, the Supreme Court said that the RBI has taken a consistent stand that virtual currencies are not prohibited. So, as long as virtual currencies are not prohibited, then exchanges are dealing with something which is not illegal. Then, how do you find problems with exchanges that they should not be allowed to use banking channels? If you want to curb banking channels to these exchanges, then you must come out with finding fault with exchanges that this is what they are doing, which is illegal. So far, you have not declared any of this to be illegal. Therefore, you cannot hold the activity of exchanges to be illegal, and therefore you cannot not allow banking channels to these exchanges. The third argument which Supreme Court said that all the bills that were drafted are not tabled and they have not been into law. So therefore, the 2018 bill was also the one which was fine with an idea of allowing sale and purchase of digital crypto assets at recognized exchanges. So therefore, unless this is something which is illegal, unless you make virtual currencies illegal, you cannot cut off a person dealing with virtual currencies from the banking channel. Okay. So Supreme Court has struck this down, and therefore, as of now, virtual currencies are not prohibited. The exchanges also have all access to the banking channels. Person can hold virtual currency in India. Person can go to exchange and convert the virtual currency into money as well. But things may change because there is going to be a 2019 bill. This bill is drafted, the bill copy is available. And this is where the real risk lies for the future of virtual currency in India. Because this bill very, very clearly makes the holding, selling, dealing, doing any measurement with virtual currency to be illegal. This is the bill which will declare the activity of exchanges, activity of holding, everything illegal as far as virtual currency is concerned. So if this bill comes out, then decision of Supreme Court will be set aside. If this bill was available before the Supreme Court, then Supreme Court will also not have taken the decision it took. We will have to see. This bill is still not passed, whether this bill is passed or not. But until that happens, uh, we can deal in virtual currency. If once this happens, this is very, very strict bill. But once this happens, it will become illegal. Only future will say whether this will happen or not. But if one is to look at both the strengths and weaknesses of the virtual currencies, one can see that the arguments in favor of the existence of virtual currencies, that it is a liberation from the centralized power, it is secured system, it is free from the any intermediary, including banks, it is very cost effective, it is free from the debasement of currency. It has a global reach. It's anonymous, and the arguments which the government will say that this facilitates money laundering, it facilitates terrorism financing, it facilitates tax evasion, and it allows the destabilization of the credit and monetary systems. We will see in future how these questions are dealt with at the legislative end, and how the parliament comes out with this, if they do. And that is it. Thank you very much. If there are any questions, we can take them now.
Thank you, Bandish, for the enlightening session. We can have Q&A. If anybody has any questions, we can discuss that.
Bandish bhai, I have one query.
Yes, please.
As regards to taxation perspective.
Right.
So if I hold a Bitcoin today, valuing some X amount, tomorrow if I trade it, I earn profits on it.
Right.
How would it taxed in my hands? Because then if I'm trading in a commodity, some trail would be left by me. But
Right.
if I'm dealing in Bitcoins and if I'm making any profits on that, firstly, how it would be taxed in my hands, and how I would be in a position to justify that, sir, actually this was the profit which is ought to be taxed in my hands.
See, so far the Income Tax Act of 1961 does not have specific provisions for Bitcoins, but we have the provisions for the profit from business profession and profits from capital gains. So therefore, there could be two scenarios. If you have dealt in Bitcoin as a part of your uh, trade, if this was your, if you dealt in goods or services, that was your business profession, the difference between the amount you paid in getting a Bitcoin versus the amount you eventually received while redeeming the Bitcoin to convert into the money, the rupees, including of course the gain that you made from the actual trade, etc., will be taxed as the business profession. Uh, because this, you can imagine, this is a foreign exchange fluctuation gain. Instead of foreign exchange fluctuation, this is a Bitcoin fluctuation gain. But if you use it as a hobbyist asset, if you buy a Bitcoin, you do not deal in it. You buy a Bitcoin today, 5 years later, you sell the Bitcoin. The amount that you realize is greater than the amount that you spent. You may claim that this is a capital gain. In that case, the Bitcoin will be treated as the asset. As far as the IRS, the American systems are concerned, they are treating this as the asset and subject to the capital gains. But we don't have the real problems as on today. It will be seen. Someone might argue that this is a personal effect. The money is money. I mean, we will see those interesting arguments when the matters will come before the court. Someone will say that money is money, therefore this trade cannot result into capital gain. This trade cannot result into a business. But we'll see. But I think this can be taxed under the business profession or capital gains.
I have a question, Bandish.
Yes.
Hello. Firstly, thanks for throwing light on a very rare subject.
Oh, pleasure.
The question is, as you said that the bill is going to be very strict, it is very strict, and I have not gone through it because it's a new subject to me. But would it be retrospective? Because if I've got some Bitcoins with me,
Right.
or any person for that matter,
Right.
an act cannot be like that, that it would be retrospective, that holding the bitcoins today and that coming tomorrow would be prohibited.
Yes.
And then if it would not be, it would be prospective if in case, then how would that likely damage or likely threat that the country finds could be meted with?
See, I think just the way RBI gave a 3-month period to the banks to sever the relationships, this bill could also do similar like this, where there could be enough consultation with the people and they may come out with a timeline that in 3 months dispose of all your virtual assets, do not hold anything, and therefore if you do not hold after 1st April, let's say 1st April 2021, this bill is going to be effective from 1st April 2021. So dispose of anything before that. If you are holding after that, and if you are caught, because the question also comes up as to how you are caught, because this is the which European Parliament also discusses this, that to find the holders is also highly difficult. But let's say hypothetically, if you find the holder after 1st April 2021, maybe then they will find them punishable. So there could be a time gap for people to
But will it not take to a legal battle, that can you say that something which was not an offense on a particular day, and now with an act you say that this becomes an offense, so within 3 months you have to do this and that? I would say that it was never an offense, it was not prohibited, so I am having it.
see. Imagine the helmet. We until few years not wearing a helmet was not an offense, but now not wearing a helmet is an offense. That is not. I don't think there's a valid argument to say that something that is not an offense cannot be an offense for all times to come. The government can declare an offense. So, but they cannot do it retrospectively for sure. That is not going to happen. But I do not think that one can challenge the action of the government on the ground that because it was not an offense earlier, this is not an offense now. One could argue that this is a property, so holding of a property cannot be an offense. But that we will see once the bill is framed, tabled, and then I'm sure the challenges will come and
Will be
very
very interesting.
will
Thank
come.
you, thank you,
Sure.
thank you.
Okay.
I think we can end the session today. Thank you, Bandish.
Thank you, Archit. Thank you very much. It was a lot of fun.
It was a lot. Thank you.
Bye bye.